here today because I understand and appreciate the importance of congressional oversight and because I'm committed to ensuring the highest standards of integrity and professionalism at the United States Department of Justice. That's precisely what I pledged to do exactly 3 years ago tomorrow when I was sworn in as Attorney General, and it is exactly what I have done over the last 3 years. My dedication to the Department's mission is shared by an extraordinary group of colleagues, over 117,000 employees who each day in offices all around the world work tirelessly to protect the American people from a range of urgent and unprecedented threats, from global terrorism and financial fraud, violent crime, human trafficking, civil rights abuses, and more. Over the last 3 years, we've made a number of significant improvements, including policy and personnel changes that address many of the concerns that are the subject of this hearing today. Today, I'd like to discuss some of these improvements in specific terms and outline the steps that we have taken to ensure that the flawed tactics in Operation Fast and Furious and in earlier operations under the prior administration are never used again. Now, in some of my comments today, if they sound familiar, it is because this marks the 6th time that I've answered questions about this operation before a congressional committee in the last year. Let me start, however, with something that cannot be said enough. Allowing guns to walk, whether in this administration or the prior one, is wholly unacceptable. I've been consistent on this. I've said this from day one. The tactic of not interdicting weapons, despite having the ability and legal authority to do so, appears to have been adopted in a misguided effort to stem the alarming number of illegal firearms that are trafficked each year from the United States to Mexico. Now, to be sure, stopping this dangerous flow of weapons is a laudable and critical goal, but attempting to achieve it by using such inappropriate tactics is neither acceptable nor excusable. And that's why, when I learned early last year about the allegations raised by ATF agents involved with Fast and Furious, I took action. In addition to requesting an Inspector General investigation last February, I ordered that a directive be sent prohibiting the use of such tactics. There have also been important personnel changes in the Department and vital reforms reflecting the lessons that we have learned from Operation Fast and Furious have been implemented. Today, I want to reaffirm my commitment to ensuring that these flawed tactics are never used again, and I reiterate my willingness to work with Congress generally and with this committee more specifically to address the public safety and national security crisis along our southwest border that has taken far too many lives. Congress has legitimately sought answers to questions about law enforcement operations Wide Receiver and Fast and Furious, and my colleagues and I at the Department of Justice have worked diligently to provide those answers. In addition to my frequent testimony before Congress, I have answered and am continuing to answer questions that have been submitted for the record during previous hearings. The Department has also responded to more than 3 dozen letters from members of Congress and facilitated numerous witness interviews. We have also submitted or made available for review some 6,400 pages of documents to congressional investigators. This has been a significant undertaking for Justice Department employees, and our efforts in this regard remain ongoing. We've also provided Congress with virtually unprecedented access to internal deliberative documents to show how inaccurate information was initially conveyed in a letter sent to Senator Grassley on February the 4th, 2011. Now, these documents show that Department officials relied on information provided by supervisors from the relevant components in the best position to know the facts. We now know that some of the information that they provided was, in fact, inaccurate. We also understand that in subsequent interviews with congressional investigators, these supervisors stated that they did not know at the time that the information that they provided was inaccurate. In producing internal communications regarding the drafting of the February 4th letter, the Department made a rare, limited exception to longstanding executive branch policy. This decision reflected unusual circumstances and allowed us to respond in the most comprehensive way possible to congressional concerns where the Department itself concluded that information in the letter was inaccurate. The documents we produce have answered the question of how that letter came to be drafted and put to rest questions of any intentional effort to mislead. All of our communications to Congress should be accurate, and that is the standard that I expect the Department to meet. At my direction, the Deputy Attorney General has instituted new procedures to increase safeguards in this area. As I testified in a previous hearing, the Department does not intend to produce additional deliberative materials, and I want to emphasize deliberative materials about the response to congressional oversight or media requests that postdate the commencement of congressional review. This decision is consistent with the longstanding approach taken by the Department under both Democratic and Republican administrations and reflects concerns for the constitutionality and the constitutionally protected separation of powers. Prior administrations have recognized that robust internal communications would be chilled and the executive branch's ability to respond to oversight requests thereby impeded if our internal communications concerning our responses to congressional oversight were disclosed to Congress. For both branches, this would be an undesirable outcome. The appropriate functioning of the separation of powers requires that executive branch officials have the ability to communicate confidentially as they discuss how to respond to inquiries from Congress. Now, I want to note that the separation of powers concerns are particularly acute here because the committee has sought information about open criminal investigations and prosecutions. This has required Department officials on how to accommodate congressional oversight interests while also ensuring that critical ongoing law enforcement decision-making is never compromised and is free from even the appearance of political influence. Such candid internal deliberations are necessary to preserve the independence, the integrity, and the effectiveness of the Department's law enforcement activities and would be chilled by disclosure to Congress of such materials. Just as we have worked to accommodate the committee's legitimate oversight needs, I trust that the committee will equally recognize the executive branch's constitutional interest and will work with us to avoid further conflict on this matter. I know the committee is also keenly interested in the policy changes that the Department has undertaken in the wake of Operation Fast and Furious. The ATF, which is now under the leadership of Acting Director Todd Jones, has implemented a number of key reforms and critical oversight procedures to prevent such a flawed operation from occurring again. These reforms are numerous and include a number of things. I'm also pleased to report that under the leadership of the Department's Criminal Division, we have bolstered crime-fighting capacity on both sides of the U.S.-Mexico border, and we have done this by doing a number of important things as well. This is an important start, but we have to do a lot more, and no one knows this better than the members of our nation's law enforcement community, including, and I want to emphasize this, including the ATF agents who testified before this committee last summer. Not only did these brave agents bring the inappropriate and misguided tactics of Operation Fast and Furious to light, they also sounded the alarm for more effective laws to combat gun trafficking and to improve public safety. These courageous agents explain that ATF's ability to stem the flow of guns from the United States into Mexico suffers from a lack of effective enforcement tools. Unfortunately, in 2011, a majority of House members, including all the members of the majority on this committee, voted to keep law enforcement in the dark. Individuals purchased multiple semi-automatic rifles, shotguns, and long guns, like AK-47s, in gun shops along our southwest border states. In this new year, I hope that we can work together to provide law enforcement agents with the tools that they say they desperately need and that they have requested to protect our citizens and to ensure their own safety. Indeed, incidents of violence against law enforcement officers are approaching the highest level that we've seen in nearly 2 decades, even though violent crime is down overall. That is simply unacceptable, and the Justice Department is committed to turning back this rising tide and to protecting those who serve on the front lines. We've designed and implemented a comprehensive new training initiative to provide law enforcement leaders with the information, analysis, and tools that they need to respond to a range of threats. Let me be clear, nothing is more important than ensuring the safety of the brave law enforcement professionals who put their lives at risk for us each and every day. But we can't make the progress we need and that the law enforcement partners that we have deserve without your assistance and without your leadership. As I said before, I'm determined to ensure that our shared concerns about these flawed law enforcement operations lead to more than worn-out Washington gotcha games and cynical finger-pointing. The Department of Justice stands ready to work with you, not only to correct the mistakes of the past, but also to strengthen our law enforcement capacity in the future. Thank you.
I thank the gentleman. Before I begin my questioning, Mr. Attorney General, would you agree to release to us legal opinions on the constitutionality of the material that you have thus far refused to supply the committee?
To the extent that there are legal opinions, I will look at them, and to the extent that they can be provided, I have no objection to that. I don't know if these are OLC opinions that OLC would have an objection to providing, but to the extent that I can, I will make those available to you.